Okay, yeah, sorry for the delay. And thanks everybody for coming. My name is Eric. I'm a graduate student at MIT in the Department of Brain and Cognitive Sciences, and the title of the work I'll be presenting on is So Much for Plain Language, an analysis of the accessibility of US federal laws over time. As you probably saw on the title slide, this is joint work with two amazing collaborators, including Frank Mollica, who's a faculty at University of Edinburgh, and Ted Gibson, who's a professor and my advisor at MIT Brain and Cognitive Sciences. And just to give a little background about the project, as many as are well aware, there's a burgeoning psycholinguistics literature documenting the various ways in which efficiency shapes human language, such that successful communication can be achieved with minimal effort on average by the sender and receiver. So, for example, at the lexical level, one way in which this efficiency manifests itself is through word length, as shorter words such as the tend to be, more frequent words such as the tend to be shorter than less frequent words such as the accordion, such that utterances tend to be not longer than necessary given one's communicative aims. A second example is that at the syntactic level, for example, words that depend on each other tend to be close together so as to not overload working memory capacity when interpreting an utterance. Now, one sort of domain in which this efficiency has been attested to not apply is the legal system, as the language in contracts, statutes, and other legal documents have often been observed to be notoriously inaccessible to lay people, such that at least on the comprehender side, legal content seems to not be understood by a listener with minimal effort. And from a psycholinguistics perspective, this is obviously poses a problem for people trying to read the documents, but from a legal perspective, it also poses a problem for the legitimacy of the documents themselves, as well as certain aspects of legal doctrine. So, for example, in U.S. constitutional law, the fair notice doctrine requires that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that they may act accordingly. In other words, at least under one interpretation, insofar as laws are incomprehensible to a typical layperson, this would imply that they're not giving lay people fair notice, which would in turn undermine the legitimacy of those laws. Meanwhile, the ordinary meaning doctrine, which is an interpretive principle not just in US law, but across jurisdictions around the world, this requires that words in legal documents typically be interpreted according to as they're ordinarily understood by lay people. However, insofar as they're not ordinarily understood by lay people, the coherence and legitimacy of this doctrine would be undermined as well. So we're not the first people, obviously, to notice this problem. And in fact, government officials in various countries have noticed this problem and have tried to do things about it. And in the US, in particular, government has engaged in a series of top-down efforts to simplify legal documents for the public at large. These efforts have been collectively referred to as a plain language movement. So, for example, in the 1970s, Richard Nixon mandated that the Federal Registry be drafted in layman's terms, and Jimmy Carter issued executive orders intended to make government regulations easy to understand by those who are required to comply with them. The most recent call to arms is the Plain Language Act of 2010, which was passed during the Obama administration, which established formal guidelines regarding how to write government documents clearly for a layperson. However, there remains no systematic evaluation of A, how effective these efforts have been, nor B, of how accessible public legal documents are relative to more standard varieties of English more generally. And so the goal of our study was to evaluate both of these questions. And the way that we tried to do that was through a corpus analysis of every law passed by Congress between 1951 and 2009, as well as concurrent resolutions not passed into law and presidential proclamations. And we compared those with a broad sample of English texts drawn from the Corpus of Historical American English, which included a pretty large sample of fiction books, nonfiction books, magazine articles, and newspaper articles published over the same time period. And within those texts, we sought to determine the prevalence of certain metrics that are A, associated with psycholinguistic complexity, B, whose use is discouraged by the Plain Language Act, and or C, have been attested to be common in legal texts. So as to get a sense of whether these features have declined over time as a result of the plain language movement, and just more generally to see to what extent they're actually prevalent in laws relative to non-laws. And so specifically, we looked at the presence of 5 features, each of which I'll kind of go over briefly. The first is center embedding, which just involves a case in which a clause is embedded within the center of another clause as opposed to being separated out into a separate sentence, as in the text here. So any applicant who has been a victim of the discrimination, which is a subject of such proceeding or civil action, may bring an action under the section. The red text is embedded into in the center of the main clause. Any applicant may bring an action under the section, which separates important words that depend on each other from each other, and violating one of the traits of efficiency that we talked about at the beginning. So that's one. The second is low frequency jargon. So something like ab initio, hereinbefore, aforesaid. Basically terms that are like infrequently used in everyday speech and that are like they cause processing demands when they are used in everyday speech. The third thing we looked at were higher frequency synonyms. So we were interested not just in whether or not there were low frequency words in laws, but ideally low frequency words, or I mean, ideally from a point of view, but just we're interested in how many of those words, I guess, could be replaced by a higher frequency term that had the same meaning. So bad faith is basically an English term for the Latin term malefides, which tends to mean the same thing in legal context. The fourth thing is passive voice. So no further amendments shall be enacted by Congress. So passive voice structures are required later than active voice structures. And there's seems to be some mixed evidence that they actually induce processing difficulty, but they're attested to be very, very common in legal documents, and their use is discouraged by the Plain Language Act. So we decided to include them here. Seemed like to on the side of caution. And then the fifth thing was non-standard capitalization. So distributions of undistributed taxable income previously taxed to shareholders. That's like, I mean, maybe the capitalization isn't the worst thing about this, but this is a type of thing that is especially common in certain contract provisions for like limitations of liability and warranty disclaimers that have to be conspicuous in order to be legally upheld. And courts have kind of interpreted, or I guess the drafters have interpreted conspicuous to basically just mean like all caps, and so ostensibly that's for the benefit of the reader to make sure that you're actually reading it and understanding it. But there seems to be evidence that doesn't aid comprehension, and in some cases might not might inhibit it. So those are the 5 features, and just to, I guess, provide some evidence that they actually do inhibit processing difficulty. In a previous study, we actually compared the comprehension and recall accuracy of legal text written with these features in comparison to legal text of equivalent meaning without these features. And so here on the left is the graph for comprehension accuracy, which is the metric on the y-axis, and on the x-axis is the type of legal text. So legalese here just refers to text drafted with the features that we just went over, and simple refers to texts that don't have those features. And as you can see, the comprehension is lower for the legalese text than the simple text. We found the same thing in a separate study where we gave participants additional monetary incentives for accuracy, and also gave them the text in front of them so they could just have the text while they're answering the questions as opposed to doing it from memory. And also we found the same thing if giving participants a recall task as opposed to just a comprehension task. So those are that's just to give further context about the metrics. In terms of how we calculated them, we just used some pre-existing natural language processing tools. So a lot of it was with the Stanza NLP package from the core NLP group at Stanford, which we used to dependency parse each sentence, tokenize each sentence into words, and tag each word by part of speech. We also used WordNet, which is the lexical database of English for our frequency and synonym metrics, along with the SubtleX word frequency dictionary, which we also use for our frequency and synonym metrics. And so in terms of what we found for basically any given year between 1951 and 2009, virtually every metric was present to a greater degree in federal laws relative to any other 4 baseline genres of English, and in most cases the difference was pretty striking. So In our visualizations here, the x-axis is the year of publication of a given text, whereas the y-axis is the mean value per sentence of a particular feature. So beginning with center embedding on the top left here, what we have is a scatter plot with each dot showing the percentage of sentences that were detected to have a center embedded clause over time in each corpus, as well as the fitted low S regression lines capturing the best fitting trend. And as you can see here, law on top is in red, far above the other 4 genres, which are nonfiction in purple, newspaper articles in blue, magazines in green, and fiction in greenish yellow. Similar patterns are observed for other metrics, including passive voice, capitalized words, and average word frequency. Our synonym metrics also had converging results, though for the sake of space, it isn't included. I guess also note for the sake of consistency across graphs, frequency is mapped to complexity, which is why low frequency words are on top, high frequency words are on the bottom. And so one other result that you can kind of get a feel for in this graph is that with one exception, our analyses did not find a meaningful change in prevalence over time in any of the metrics. And in the one case where there was a meaningful change, it actually went in the opposite direction. So as you can see, the bottom left, capitalized words actually increased as a result of the onset of the plain language movement, such that like all the other metrics, legal texts now have a higher index of words with non-standard capitalization than non-legal texts. So those are kind of the results in terms of what this all means in relation to our questions. The first takeaway is just, laws have and continue to contain a strikingly large amount of difficult to process features relative to non-legal texts. And given this, given the fact that this prevalence hasn't changed over time, this suggests that top-down efforts to simplify legal language have failed. Relatedly, this failure, as alluded to at the beginning of this presentation, the failure to make documents accessible to lay people undermines both the legitimacy of the documents themselves, as well as the legitimacy of other legal doctrines whose validity rests on the idea of documents being accessible to lay people. One question you might ask is just, why is this the case? Why do lawyers and lawmakers continue to write this way despite top-down efforts to simplify language? This question is obviously crucial to informing the policy question of how do we get lawmakers to change the way that writing so as a result of these issues. And it's a question we've been attempting to address in ongoing work. There's kind of been 3 broad sets of hypotheses that have been proposed to answer this question. The first is that legal language simply has to be complex in order to satisfy some sort of communicative aims. The second is that it can be simplified, but lawyers don't sufficiently care or want to relative to other priorities. And the third is that lawyers just don't know enough about the relationship between language and cognition to know how best to simplify it. Obviously, this wasn't the purpose of our study here to evaluate those, but I'm happy to talk about it offline or in Q&A, assuming that's still a thing after the delay here. But anyway, yeah, thanks so much for listening. I really appreciate your attention, and yeah, looking forward to hearing any thoughts that you might have about this.